We have attorney, I should say, Michael Leonard. He's a federal criminal defense attorney who's joining us right now via Zoom. First of all, thank you so much for taking time out of your day to be here with us. I know we have a lot of questions, a lot to sort through. Can you kind of walk us through, what goes on in the courtroom in a situation like this right now?
Sure. This is a somewhat limited hearing. It's a request for a temporary restraining order. So the judge and the parties are limited to what is in the 69-page complaint. And I know you mentioned that it's pretty meaty. And really the goal for the judge in this case is to decide, do the plaintiffs, meaning the city of Chicago and the state of Illinois, do they have a reasonable likelihood of success on their legal claims, all those counts, the 10 or more counts that they have different legal theories? And is there irreparable harm that the plaintiffs will suffer if the temporary restraining order is not granted?
And Michael, would you predict that this ruling, I mean, we don't want to make predictions, but we looked at what happened in Oregon, and the rulings pertaining to this issue have all gone against the federal government here. So would you predict that that's a high likelihood here that this is the way Judge Perry would rule?
Yeah, I think Judge Perry is going to grant the request for the TRO and the preliminary injunction. I think you raised a lot of the good legal arguments that they're going to be making, and I think, as a factual backdrop to all this, I think the Trump administration and the Department of Defense really hurt themselves, as you guys pointed out, by making these consistent and sort of persistent statements against Chicago and how they're going to utilize these troops. And therefore, that resulted in pages and pages of facts in the lawsuit that was filed, citing statements by Trump and other members of the administration about Chicago and about the state of Chicago and how these troops would be used, which really plays into the hands of the plaintiffs who are seeking the injunction, because it shows really that they're not using them for a proper purpose that's allowed by the statute or by the Constitution.
And then would you anticipate what happens here? The temporary restraining order gets put into place, say that happens, but then the issue still gets litigated, perhaps all the way up to the Supreme Court. Do you think that eventually the Supreme Court's going to hear this sort of issue of when can the president call in the National Guard, especially if it's against the wishes of the state's governor?
Oh, 100%. I think, you have this case, you have others in the federal system, so one or more of them are going to end up in the Supreme Court, either combined, the issue combined, or one of the cases brought. But I expect that the judge will grant the TRO. Then, you have to litigate the case. You actually have to decide the case on the merits down the road, which that involves, witness testimony, depositions, live testimony, all that sort of stuff. But I think in between all that, what's going to happen is one of these cases is going to get to an appellate court, a federal appellate court, on an interlocutory basis, meaning expedited basis, and then probably end up in the hands of the Supreme Court quickly after that. So all that could happen, and it could get to the Supreme Court. It could be as quickly as 3 to 6 months. It could take much longer. But this is something that I think will be heard by the higher courts on an expedited basis pretty promptly.
Attorney Leonard, I want to ask you this question. If Judge Perry actually sides with the city of Chicago on this and the state of Illinois, does the federal government, meaning the Trump administration, do they have any leg to stand on a legal basis to fight this from their side?
Well, they can try to get it heard by the appellate court, the Seventh Circuit Court of Appeals, on an expedited basis, either through a vehicle called an interlocutory appeal or a writ. And I think the Seventh Circuit would be willing to take the case from whatever side appeals, just because of the sex appeal and the legal issues presented. So yeah, I think they'll certainly attempt to appeal it. If that move to appeal it immediately is denied, then they would proceed with the proceedings and have a real evidentiary hearing where you have a witness testimony and that sort of thing.
Do you read, I mean, we keep citing the Posse Comitatus Act. This is the federal law that sort of determines what the parameters here are, and it's pretty clear that the president can only federalize National Guard if it's insurrection, if it's rebellion, if it's an invasion. But do you see some area in the law where the president does have the ability to argue, well, it's just to guard federal property, and in that case, the president does have this power, even if the governor opposes it?
Yeah, they'll certainly be arguing that this morning, but I don't think that's a good argument. I think you hit on those points earlier. Traditionally under the statute, it would be rebellion, insurrection, invasion. There is a third clause, which it's a little bit more ambiguous, that says if regular forces aren't sufficient to enforce federal law, you could theoretically call it the National Guard, but that doesn't fit this situation either. So I think, number one, the big issue before the court today will be, did Trump even have the authority to order the troops to be called up at all? That could end the issue right there. And then secondly, even if he did, are they being used for a purpose that's allowed by the statute and by the Constitution? So I think you're right on these legal issues. And I think that in both instances, Judge Perry's likely to come down on the side of the city of Chicago and the state of Illinois.